Hi, so welcome to another video. We're going to do the Module 3 case study, which is trying juveniles as adults. We're going to cover two different court cases. This video, we're going to put both court cases in one video to try to keep things a little short. Plus, there's not a whole lot of information on each one, so we're just going to keep it pretty simple and just do both of them in this one PowerPoint. So let's go ahead and get started. But first, for this assignment is a little different than others. This one, you're going to have to go ahead and click on the tips for writing persuasively link that you'll find in the lesson. That's going to give you a template for writing a persuasive essay. Okay, so you're going to need to be able to identify at least two court cases that support your opinion on whether or not you believe juveniles should or should not be treated as adults in court, and whatever other evidence you can find, whether it's an amendment or law or things like that. Now, these are some key terms that you're going to need to know during this video. Exclusive jurisdiction. That basically refers to the powers of a court to adjudicate a case to the exclusion of all other courts. So that basically means that the juvenile court has exclusive jurisdiction. They are responsible for determining the outcome of the child in question. They can waive their exclusive jurisdiction and send the case to a district court. However, there are procedures for that, which we're going to cover soon. Due process, which is basically just the fair treatment through the normal judicial system. And then the Eighth Amendment, which deals with cruel and unusual punishment. Okay, this was ratified in 1791 as part of the Bill of Rights. So this dates back more than 2 centuries ago. And we're going to discuss the meaning of the word cruel. That's a very subjective and vague term to use in the Constitution. So we're going to go ahead and review how should that word be interpreted. All right. So first is Kent versus the United States. So this is the summary of this court case right here. Morris Kent, he was a 16-year-old boy who was detained and interrogated by police in connection with some robberies and even a rape. When he was picked up, he was questioned. His mother didn't even know he had been picked up for, I believe it was like 24 hours. And the court ended up waiving its jurisdiction and sending this case to the district court without doing a full investigation. Now, Kent's lawyer claimed that this was in violation of the Juvenile Court Act. But regardless, the district court found him guilty. The jury found him guilty and sentenced him to 30 to 90 years in prison. And the courts of appeals in D.C., they affirmed that decision, even though they did note that the juvenile court judge did not provide any kind of reason for the waiver. So this is going to come into question as to whether or not the waiver was legitimate. So was the juvenile court's waiver of jurisdiction valid? So here we are with the majority opinion. What happened here is the court ruled that the full investigation did not take place. A full investigation was needed for a waiver to be valid. So the provisions of the Juvenile Court Act basically stated that any kid that is 16 years or older and is charged with an offense that could be considered a felony in adult court, or any kind of crime that could be charged, any kind of charge that could end the person up in prison for life or through the death penalty, requires a full investigation, requires full due process. And the court is basically saying that we're not certain if this actually happened. So the court ruled that this should return back to the lower courts to determine if the waiver was actually valid. What ended up happening eventually is Kent ended up being put in a mental institution because his lawyer had claimed that he was not mentally sound. And so he ended up being put into a mental institution, ended up being later released. And it's really kind of hard to find out what else has happened to him since then because he's kept his nose clean and hasn't been in trouble with the law since. But that was the overall outcome of the Kent case. Next, we're going to cover Roper versus Simmons. This took place in. So in this case, Christopher Simmons, he was sentenced to death for a crime he committed in 1993, when he was 17 years old. There was a series of appeals in the state and federal courts that lasted until 2002. But each appeal was rejected. Then in 2002, the Missouri Supreme Court stayed Simmons' execution, while the U.S. Supreme Court decided Atkins versus Virginia. Now, what I mean by they stayed is they went ahead and they held off. They're like, hold on, we're not going to do anything yet. Let's wait and see what the Supreme Court says about Atkins versus Virginia, so we know how to rule in this case. See, Atkins versus Virginia was a case that dealt with the execution of a mentally disabled person. So they made some sort of connection between executing a mentally disabled person and a juvenile, probably on the basis of, cognitive development. So what happened here is after the U.S. Supreme Court ruled that executing a mentally disabled person violated the Eighth Amendment, which was a prohibition against cruel and unusual punishment. They did so because they felt that most Americans felt that it would be cruel to execute someone who was mentally disabled. So that was their reasoning for ruling in Atkins versus Virginia. So that had an impact on the Missouri Supreme Court ruling for Simmons. Now here's where it gets a little tricky though. Okay, using that reasoning from the Atkins case, the Missouri Supreme Court decided in a 6-3 decision that the U.S. Supreme Court's 1989 decision. Now this is the U.S. Supreme Court, not a state. This is the federal court. Their decision in Stanford versus Kentucky, which held that executing a minor was not unconstitutional and not cruel, was no longer valid. Okay, so the opinion of Stanford versus Kentucky had relied on the findings of the majority of Americans did not consider the execution of a minor to be cruel and unusual. This was in 1989. Now the Missouri court cited numerous laws passed since 1989 that limited, the use of the death penalty, and held that the national opinion had changed on the matter. So, finding that the majority of Americans were now opposed to executing minors, the court held that such executions were now unconstitutional. Now, keep in mind, this is a state Supreme Court overturning a decision of a U.S. federal court, the highest court in the land. That just doesn't seem right. You can't. There's a hierarchy system when it comes to the courts. So the state court is overruling the decision of the federal court. So on appeal to the U.S. Supreme Court, the government argued just this. They argued that allowing a state court to overturn a Supreme Court's decision by looking at evolving standards, as they said, would be dangerous because, well, it could also work the other way. Because the state could just as easily decide that the execution prohibition by the Supreme Court, such as the execution of a mentally ill person in Atkins versus Virginia, were now permissible. Well, we could do it now because, the American people's beliefs changed. So this decision, the argument of the government here in this case is that overturning a decision like that should not be left up to a state Supreme Court. They should not be able to overturn the federal decision of the U.S. Supreme Court decision. So, does the execution of a minor violate the prohibition of cruel and unusual punishment found in the Eighth Amendment? Well, the majority opinion said yes. They sided with the Missouri Supreme Court. They sided, with the juvenile in question who was sentenced to death in a 5-4 decision. So this wasn't unanimous. It wasn't it was only 5-4. There was 4 justices that disagreed with this opinion. So this is very controversial. This opinion was delivered by Anthony Kennedy. The court ruled that the standard of decency has evolved so that executing a minor is cruel and unusual punishment. Notice the words he says, evolved. So the word cruel has evolved and changed over time. So therefore, the court's ruling on the matter has changed over time. So the majority cited that a census against the juvenile death penalty among state legislatures. So the states generally were not allowing the death penalty of a minor. So because the states were passing laws against, the death penalty of a minor, and also its determination on the death penalty is disproportionate punishment for minors. So it's not really used that often, even in places where it's allowed. So finally, the court also pointed out to an overwhelming international opinion against the juvenile death penalty. So basically what that's saying is overwhelmingly most other developed nations around the world, particularly in Western civilization and Western Europe, that we're most closely related to, they do not allow the death penalty of a minor. They find it to be cruel and unusual. So one of the arguments is that, well, international opinion on this is against it, so we should be too. That's just one of the arguments. So these are multiple arguments for their decision. Okay, so here's the time for the dissenting opinion. This was written by Justice Scalia. Justice Scalia, in his argument, quoted Alexander Hamilton from the Federalist Papers number 78. He said, "In urging approval of a constitution that gave life-tenured judges the power to nullify laws enacted by the people's representatives, Alexander assured the citizens of New York that there was little risk of this." See, they were worried that giving this much power to people who serve for life on the Supreme Court, the power to nullify laws by the people that were voted to represent the people, was just too much. And his argument was that it's not too much. It's okay, because the judiciary doesn't really have neither the power of force or will, but merely of judgment. This was found in Federalist number 78. But Scalia argued that Hamilton had in mind a traditional judiciary, quoting Hamilton as he said, "bound down by the strict rules and precedents which serve to define and point out their duty in every particular case that comes before them." So because there was these rules that the judiciary had to follow and precedents, it was okay that they had this power. Now, he goes on to say, and this is Scalia being Scalia, he said, "Bound down indeed. What a mockery today's opinion makes of Hamilton's expectation, announcing the court's conclusion that the meaning of our Constitution has changed over the past 15 years. Not, mind you, that its decision 15 years ago was wrong, but simply that the meaning of the word has changed." He's referring to the 1989 decision in Stanford versus Kentucky, which ruled that the death penalty of a minor was not unconstitutional. Well, he's saying that 15 years later, for the meaning of the word cruel to have changed is absurd. That the justices should not be able to determine what a word means, but it should mean what it meant the day it was written in 1791. And then if you want to change the meaning of the Constitution or the meaning of an amendment, well, then you have to amend the Constitution through the Fifth, which is what's identified in Article 5 of the Constitution, the Amendment Clause. If you want to change the meaning, then you should amend it through the legislatures. He doesn't believe that the unelected, life-tenured judges should have the power to do just that. And he didn't believe that Hamilton had that in mind when he was advocating for the Constitution in 1787. He continues and he says, "The court thus proclaims itself sole arbiter of the nation's moral standard. And in the course of discharge, that awesome responsibility purports to take guidance from the views of foreign courts and legislatures." He's completely against the idea of looking at foreign courts and legislatures. "Because I do not believe that the meaning of our Eighth Amendment, any more than the meaning of any other provision of our Constitution, should be determined by the subjective views of 5 members of the court and like-minded foreigners. I dissent." So, if you agree with them, great. If you don't, that's fine. This is a 5-4 decision, so you've got to look at the dissent and the majority opinion just as equally, because they could have gone the other way just by 1 vote. So the resources here, there's some court cases there. I'll go ahead and put those in the description below. There's a link for pros and cons of trying juveniles as adults. which will certainly come in handy whenever you are making your argument for or against. And then also there's this interesting Netflix original, Murder to Mercy. Check that out. This girl was convicted of murder when she was 16, and she was later released because she was sentenced to life in prison and tried as an adult when she was 16 years old. So go ahead and check that out. I hope this was helpful. If you have any questions, feel free to give me a call, okay?